Okay then, to our final video in this series, we have our background, our context from videos 1 and 2. Here we talk then about the Supreme Court judgment itself in State, Ryan and Lennon, and we're just going to talk about 2 of the judgments of the 3. There were 3 judges, actually only 3 judges on the Irish Supreme Court at that time. Murnaghan was the, as it were, the Anthony Kennedy of the day. He was the moderate one in the middle, if you like, and Hugh Kennedy, the Chief Justice, and Gerald Fitzgibbon were the other 2 judges, and it's their judgments we will look at today. To Fitzgibbon first, in summary, Gerald Fitzgibbon says, look, Article 50 of the Constitution, the amendment provision, which we talked about in video 2, says what it says. There in black and white in the text, it provides the Oireachtas, the capacity or power to amend the Constitution for an 8-year period by ordinary legislation. There was no eternity clause. That is to say, there was no express protection of any particular constitutional provision, any rendering of any particular constitutional provision immune from amendment in this way. That may have been an oversight by the drafters. He doesn't quite say that, but I mean, effectively, he's kind of saying that may have been an oversight, but it is what it is. And I'm a mere judge. My job is to simply apply the law, and I have no basis, he says, effectively, upon which to block government from doing what it has done. He waves the amendments through, the number 16 amendment, the number 17 amendment. He says they are not inconsistent with the Constitution, and that's the long and the short of it. Now, that's in terms of overview and ultimately the decision, I suppose, that Fitzgibbon reaches. But I suppose his judgment is interesting because of the manner in which he reaches it. Okay, and I would just draw your attention. You should read the judgment itself, even though it's kind of hard work. It's drafted in a very elegant, ornate way, which makes it maybe a little less accessible. But I would just draw your attention to 3 related, very closely related themes in Gerald Fitzgibbon's judgment. First off, skepticism, deep cynicism, actually, about this notion of natural rights, immutable rights, inalienable rights. Okay, so this notion argued for by or on behalf of Jerry Ryan and his 3 friends, that there were certain immutable natural rights that the legislature just simply could not violate, and that they had violated them, if you like. So Gerald Fitzgibbon says, look, this is nonsense upon stilts, as Jeremy Bentham would have it. He didn't quite quote Bentham, he quoted lots of figures, Jean-Jacques Rousseau, Thomas Paine, and several others. But he just says on page 230, they assert, that is, lawyers for the applicants, assert that there are certain rights inherent in every individual which are so sacred that no legislature has the authority to deprive him of them. He says that's nonsense. He references Thomas Paine, William Godwin and others, and says, look, as Leslie Stephen, the atheist writer, a skeptic of eternal rights or natural rights, and as Leslie Stephen said, says Gerald Fitzgibbon, we just don't agree on what those rights consist in. Reasonable people disagree, presaging what modern judicial review skeptics like Jeremy Waldron, for example, would say. There is the fact of reasonable disagreement about what rights mean in practice. And he says, not only do we disagree about what rights consist in, he says, we haven't even reached an agreement on how it is we might approach resolving these disagreements. Also, incidentally, you might see a kind of a is versus ought distinction. In fact, it's interesting that Fitzgibbon on page 231 refers to, he says, we are concerned not with principles which might or ought to have been adopted by the framers of the Constitution, but we, he says, the judges are concerned with the powers which have actually been, is, entrusted by it to the legislature and executive which it set up. Is versus ought, or ought versus is, fact versus value. He says, I'm a judge. I'm not interested in morality. My job is to apply the law of the land, the fact, the is. Forget about the ought. That's for the business of moral theorists. So there you get your positivism and formalism, positivism versus natural law theory, if you like. But I think it's more the case that Fitzgibbon is a formalist, that is a textualist, if you like. He says, look, let's look at what it says in black and white. I said that at the outset. Okay. He says, when a written constitution declares that, quote, the liberty of the person is inviolable, end quote, but goes on to provide that, quote, no person shall be deprived of his liberty except in accordance with law, end quote. Then, if a law is passed that a citizen may be imprisoned indefinitely upon a letter signed by a minister, the citizen may be deprived of his, quote, inviolable, end quote, liberty. But as the deprivation will have been, quote, in accordance with law, he will be as devoid of redress as he would have been under the regime of a French or Neapolitan Bourbon. Okay, so it's a really cynical, I think it's a wonderful judgment. I mean, I don't agree with it, but it's really sarcastic. He says, look, the law is what it says in black and white on the text. End of story. And then the final theme, so that's legal formalism, textualism. The final theme, and of course it's a very related theme, in Fitzgibbon's judgment is as to the nature of judicial power, the limits of judicial power. So I bring your attention to page 236 of his judgment. But he says, I can find no justification for a declaration that there was some, quote, spirit embodied in our original constitution, which is so sacrosanct and immutable that nothing antagonistic to it may be enacted by the Oireachtas. The court has no jurisdiction, he says, to express an opinion upon any questions other than the constitutionality of the amendments before us and their correct interpretation, once the legislature has thought fit to enact them. And then he goes on to refer to some US jurisprudence, Walker and Cincinnati, where he quotes a judge in that case saying, courts cannot nullify an act of the state legislature on the vague ground that they think it opposed the general latent spirit supposed to pervade or underlie the Constitution, where neither the terms nor the implications of the instrument disclose any such restriction. So, you see, skepticism about judicial power, very reminiscent of the much later writing of great scholars like, as I say, Waldron, Bentham, Richard Bellamy, and others who are skeptical about judicial power and judicial review for reasons around reasonable disagreement as to what rights mean. Final point on Fitzgibbon, he ends it with just a great line. You know, he's just having fun at this stage, I think, and he reworks a line from Shakespeare's Richard II. He says, these are the conditions under which liberty is enjoyed and justice may be administered in, quote, this Eden demi-paradise, this precious stone set in the silver sea, this blessed plot, this earth, this realm, this Seerstadt, this free state, replacing the word this England from Shakespeare's Richard II. So we get that real sarcastic, cynical, you know, and of course Fitzgibbon was a Protestant unionist, and we understand from Gerard Hogan's writing and other that he was skeptical about this state. He was a unionist. And also I suppose it's worth bearing in mind that Fitzgibbon came from and was educated in that tradition of British parliamentary sovereignty, where Parliament was supreme. And here in this Free State Constitution we had something very novel, right? We had something very different from that, I should say. We had judicial supremacy, which vested great power in judges. Perhaps it might be that Fitzgibbon just was not comfortable with that, did not want to exercise this vast power that he and his colleagues on the bench had been granted under the terms of this constitution. Do you know what I'll do? I think, given it's 10 minutes now, I'll do another video for Kennedy, which is my favourite judgment.